The courtroom smelled like old wood and floor wax. I remember that detail so clearly, the way a scent hit me the moment I walked through those heavy double doors, the way my heels clicked too loudly on the floor, the way every head turned to look at a woman who was supposed to be invisible. I was 61 years old, standing in a family court in Ottawa with a manila envelope tucked under my arm, and my husband of 32 years was sitting across the aisle pretending he didn't know me. That morning, I had woken up at 5:30, made myself a cup of tea, and sat at the kitchen table in the house I had paid for, looked out at the backyard garden I had planted, and told myself that today was not the day to fall apart. I had been saving that for later. Maybe never. My name is Dorothy Callahan, and this is the story of how I spent the better part of my adult life building a man into someone he had no intention of staying. I met Gerald in the spring of 1985. I was 28, working as an office administrator at an engineering firm in downtown Ottawa. He was 29, finishing his last year of a business degree at Carleton, living in a basement apartment in Centertown, and absolutely certain that the world owed him something extraordinary. That certainty was, at the time, one of the things I found most attractive about him. He carried himself like a man who already knew where he was going. I mistook that for ambition. It took me 3 decades to understand it was something closer to entitlement. We dated for 2 years. He was charming in the way that certain men are charming when they need something from you present, attentive, full of plans whispered over late dinners. He talked about wanting to go back to school, to get his MBA, and eventually open his own consulting firm. He had a vision, he said. He just needed the right foundation. We got married in June of 1987. I was 30 years old. I wore my mother's pearl earrings and cried during the vows, not because I was overwhelmed by happiness, but because my father had died the previous winter and his absence felt enormous inside that church. My husband squeezed my hand at the altar, and I thought I genuinely believed that this man would be beside me for everything that followed. 6 months after the wedding, he came to me with the application forms for the MBA program at the University of Ottawa. He had already filled most of them out. He just needed my signature on the joint financial declaration. I signed. I want to be honest about what I understood at that moment. I knew what I was agreeing to. I was not naive. We had talked about it in the abstract, the way couples talk about futures that feel safely distant. But when the papers were in front of me, real and specific, something in me hesitated. I remember putting the pen down for just a second. He noticed. "You don't have to if you don't want to," he said. But the way he said it, the slight flattening of his voice, the careful neutrality made clear that there was only one acceptable answer. I picked up the pen. I signed. The program was 2 years. During those 2 years, I worked full-time at the engineering firm, took on every overtime shift available, and managed everything in our apartment: the cooking, the cleaning, the bills, the grocery runs after my 8-hour days. He studied. He networked. He went to department socials and came home late, smelling like wine and other people's conversations. I told myself this was temporary. I told myself I was investing in us. When he finished his MBA in 1990, he got a junior position at a mid-sized consulting firm. The salary was decent. Things felt, briefly, like they might balance out. We bought a small house in Canada. I kept working. We talked about children and agreed to wait until things were more settled. Things were never more settled. In 1994, he came to me again. He wanted to leave the consulting firm and start his own practice. He had a partner lined up, a colleague named Philip, and they had identified office space on Sparks Street. He had done the numbers, he said. It was the right time. What he needed was startup capital. We had managed to save $43,000 by that point. It lived in a joint savings account that I thought of, privately, as the emergency fund. The down payment on a better house someday, the cushion between us and catastrophe. He wanted to put $30,000 of it into the business. I remember the conversation happening at our kitchen table, the same table where I still drink my morning tea. He had spreadsheets printed out, projections, a business plan with tabs and section dividers. He had prepared for my hesitation. That should have told me something. "This is the moment," he said. "If I don't do this now, I never will." and I will spend the rest of my life wondering. I was 37 years old. I had been working since I was 19. I had spent the last 9 years of our marriage being the financial floor beneath everything he was building. I looked at the spreadsheets. I looked at my husband. I thought about the next 30 years of him wondering. "Okay," I said, "but I want to be involved. I want to understand the books." He nodded. He agreed to everything. The $30,000 went into the business account in March of 1994. I know the exact date because I made a note of it in the small calendar I kept in my desk drawer. I wrote the amount, the date, and the words Callahan and Morse Consulting Startup Contribution. I don't know why I wrote it down with such precision. Some instinct I didn't have a name for yet. The firm grew slowly at first, then steadily. By 1998, they had 4 employees and a client list that included 2 provincial government contracts. My husband came home later and later. He bought a better car. He started wearing different suits. He joined a golf club in Nepean that cost more per year than my first monthly salary. I was still working at the engineering firm. I had been promoted twice by then office manager, then operations coordinator. I liked my work. I was good at it. But I noticed, somewhere around that time, that he had stopped asking about it. He would come home and talk for an hour about a client dinner, a deal that was closing, a conversation he'd had on the golf course, and somewhere in there he might ask, "How was your day?" in the way you ask, because it would be strange not to. He didn't wait for the answer. I told myself this was what success looked like from the inside. I told myself I was being ungrateful. In 2003, our daughter Megan was born. I was 46 years old. We had waited so long that I had nearly stopped expecting it, and then suddenly there she was, 7 pounds, 2 ounces, born on a Tuesday morning in the Civic Hospital while my husband paced the hallway taking calls from a client in Montreal. He came in after the delivery. He held her for approximately 4 minutes before his phone rang again. Megan was, from the beginning, mostly mine. Not entirely, he could be present with her in short bursts, and she adored him with the uncomplicated loyalty that children offer even to parents who are rarely there. But the school concerts, the parent-teacher interviews, the sick days, the homework struggles, the Saturday morning skating lessons at the Merivale Arena, those were mine. I was grateful for them. I am still grateful for them. But I was also, quietly, exhausted in a way I had no language for. I retired from the engineering firm in 2015. I was 58 years old. The retirement party was small, a few colleagues, some flowers, a card everyone had signed. My husband sent a text from a conference in Calgary that said, "Congrats. Deserve it." I still have that text. I don't know why I kept it. Maybe because even then, I understood it was a document. By 2017, the consulting firm had been sold. My husband and Philip had taken a buyout from a larger company, a very good buyout, as it turned out. I knew this in general terms. The specific number, the actual amount that landed in the account, I did not know, because somewhere over the years my involvement in the finances had become theoretical. He handled it, he said. Everything was fine, he said. I had trusted him because trusting him was what 30 years of marriage had looked like. In February of 2019, I found the second account. I wasn't looking for it. I was going through a filing cabinet in his home office looking for our insurance documents because the car needed work and I couldn't find the policy number when I found a folder I didn't recognize. Inside was a bank statement, a personal account in his name only at a different bank than the one we used together. The balance was substantial. The transaction history went back 4 years. I stood in that office for a long time. Long enough that my feet started to ache. Long enough that the light through the window shifted. Then I put the statement back exactly where I found it, went downstairs, made a cup of tea, and sat at the kitchen table. I did not cry. I was past the age of crying over things I could not unknow. What I did instead was think very carefully about what I was going to do next. That evening, I called my friend Patricia, who had been my closest friend since our daughters were in the same kindergarten class in 2008. Patricia was a retired paralegal. She had been through her own divorce a decade earlier and had come out the other side with a particular kind of clear-eyed practicality that I had always admired. "I think I need to talk to a lawyer," I said. "I know one," she said, without asking me a single question. Just, "I know one." That's the kind of friend Patricia is. I met with the lawyer, a woman named Susan Okafor, whose office was on Bank Street 3 days later. I brought the calendar from my desk drawer, the one with the dates and the amounts written in my careful handwriting. I had kept it all. 25 years of small notes, the school tuition payments I had covered when the business cash flow was thin, the household expenses I had managed alone, the $30,000 from 1994. I had kept the original bank withdrawal slip. I didn't know why at the time. I know why now. Susan went through everything methodically. She didn't react with drama. She just read and made notes and occasionally asked a quiet, clarifying question. When she was finished, she looked up and said, "You have more documentation than most clients bring me after 2 years of preparation. Did you know you were doing this?" I thought about it honestly. "I think some part of me did," I said. The next several months were the strangest of my life. I went home every evening and had dinner with my husband. We watched the news. We talked about ordinary things, the weather, the neighbors, Megan's new apartment in Vancouver. I was perfectly composed. I had spent 32 years becoming fluent in the language of performing fine. I had more practice than he knew. Meanwhile, Susan was building the picture. The $30,000 in startup capital from 1994 with documentation, the years of sole financial support during the MBA, verifiable through my employment records and our joint tax returns. The household contributions, utilities, groceries, mortgage payments during the lean years, all traceable. And the private account, which Susan's inquiries revealed, contained, at its peak, just over $87,000 that had been quietly redirected from the business sale proceeds. He filed for divorce in November of 2019. I think he believed it would be simple. I think he had decided, in the comfortable arithmetic of a man who had stopped seeing me clearly decades ago, that I was someone who would accept whatever was offered, that I would be grateful for a reasonable settlement and not make things difficult. He did not know about Susan. He did not know about the calendar in my desk drawer. He did not know that I had photographed every page of that bank statement before I put it back in the folder. The preliminary hearings were in the spring. His lawyer, a man named Whitmore, younger than Megan, with a confident stride, presented a narrative in which my husband was the primary financial driver of our marriage, the architect of our comfortable life, and I was a supportive partner who had contributed in less tangible ways. The word homemaker was used in a tone that managed to make it sound diminishing without technically saying anything wrong. I sat and listened. I kept my hands folded in my lap. I had practiced this part too. The main hearing was scheduled for September 2020. By then, Megan knew. I had told her in August, on the phone, in the most neutral voice I could manage. She was quiet for a moment, and then she said, "Mom, tell me what you need. Not how could he or are you okay, just the practical, forward question. She is, in so many ways, more mine than his." The morning of the hearing, I dressed carefully. I wore the gray blazer I had bought for my retirement party. I made my tea. I sat at the table for 20 minutes. Then I picked up the envelope which Susan had prepared and which I had carried myself because I wanted to be the one to hand it over, and I drove downtown. The courtroom, the wood, the floor wax. My husband arrived with Whitmore and did not look at me. He sat with his shoulders back and his expression arranged into something between confidence and appropriate solemnity. He had always been good at surfaces. Whitmore presented their case. The division of assets they were proposing was detailed and carefully framed and left out the startup capital contribution entirely. It characterized the business proceeds as exclusively my husband's professional achievement. It noted that I had been retired for 5 years and would receive, in their proposed arrangement, a settlement they described as generous, a word Whitmore used twice, I counted. When it was Susan's turn, she was unhurried. "My client would like to submit documentation to the court," she said. The envelope went to the clerk, who brought it to the judge, a woman named Justice Renee Beaumont, who had the particular patience of someone who has heard every version of every story and is not moved by performance. Justice Beaumont opened the envelope and began to read. The courtroom was very quiet. My husband was still not looking at me. Whitmore was watching the judge with a carefully calibrated expression. The envelope contained 31 pages. There was the calendar photographed and organized chronologically. There were the bank records from 1994 showing the $30,000 withdrawal from our joint account and the corresponding deposit into the business account. There were the tax returns from 1988 through 1991 showing my income as the sole or primary earner during the MBA years. There were utility bills, mortgage statements, grocery receipts I had begun saving in 2003. Not every receipt, but enough, spread across enough years to create an undeniable pattern. There was the bank statement from the private account. And there was a simple one-page summary that Susan had prepared, a conservative estimate of my total financial contribution to my husband's professional development and the household over 32 years. The number was $412,000. Justice Beaumont read in silence for several minutes. Then she looked up, not at me, not at Susan, she looked at Whitmore. "Counsel," she said, in a tone that was perfectly level but somehow louder than if she had raised her voice. "I'd like to give you a moment to review this material before we continue." Whitmore reached for the copies Susan had provided. I watched his face as he read. That confident stride, I noticed, was not available to him while seated. My husband leaned over and they conferred in whispers. I could not hear what was said, but I watched my husband's face change the careful surfaces, shifting into something less composed, something that recognized, too late, what was happening. The hearing took most of the day. There were recesses. There were tense consultations. Whitmore requested time to respond to the documentation, and Justice Beaumont granted a brief adjournment. But the ground had shifted. Everyone in that room understood that the narrative Whitmore had built was not going to stand. The final order came 6 weeks later. I will not pretend the outcome was everything. 32 years cannot be made whole by any court ruling, but Justice Beaumont's order acknowledged my financial contribution to my husband's professional development explicitly in writing, in the legal record. The settlement was restructured. I received my equitable share of the matrimonial home. The private account was factored into the division. I received spousal support, which the order described as reflecting the significant economic disadvantage the applicant sustained as a result of the distribution of roles within the marriage. Those words, significant economic disadvantage, I read them 3 times in Susan's office when the order arrived, not because they were satisfying, exactly, but because they were accurate. Because after 32 years, something had been witnessed. I am 67 now. I live in the house in Kanata, which is mine outright. The garden is still there. The lilac bush I planted in 2001 has become enormous, and every May it fills the whole backyard with something almost unreasonably beautiful. Megan visits twice a year, and we cook together and stay up too late talking. Patricia comes for tea on Thursday mornings, and we have never once run out of things to say. My husband has remarried. I know this because Megan mentioned it once. Carefully, watching my face, I told her I hoped he was well. I meant it, the way you can mean something and also be entirely finished with it. I want to say something to anyone who might be hearing this and recognizing themselves in some part of it. Not the dramatic parts, the courtroom, the envelope, the documents. I mean the quieter parts. The moment of hesitation before signing something. The evening you realized you hadn't been asked about your day in 6 months. The retirement party where the most important person sent a text. Those moments accumulate. They become a record, not always the kind you can bring to a courtroom, but a record nonetheless. Here is what I learned, at 61, standing in a courtroom in Ottawa. Document everything. Not because you are planning for failure, but because what you contribute deserves to be witnessed. Bank transfers, financial agreements, contributions to a spouse's career or education, these should be in writing, however awkward that conversation feels. A handshake between people who love each other is not protection. A signed, dated record is. Know where your money is, not in general terms specifically. Account numbers, balances, where the statements go. I was not a careless woman, but I allowed myself to be kept at a comfortable distance from the details of our finances because it was easier and because I trusted him. That trust cost me years of clarity I deserved to have. Your contributions are real, even when no one names them. The years of overtime, the household management, the retirement funds you didn't build because you were too busy supporting someone else building theirs. These have value. Canadian family law recognizes this, imperfectly but genuinely. Know your rights. Find a lawyer who will help you understand them before you need them urgently. And finally, the thing Patricia said to me on the phone that night, without asking a single question first: find the people who say, "I know someone," before you've finished explaining. Keep those people very, very close. The lilac is blooming again this week. I had my tea this morning at the kitchen table and watched the branches move in the wind and thought about how much I almost gave away, not just the money, not just the years, but the habit of keeping careful notes in a small calendar that no one else knew about. Some part of me always knew that record would matter. I am glad I listened to that part.